Hi, my name is Scott Berry. I'm an attorney with Berry Law Offices. We're here today to talk about mechanics liens as it pertains to contractors, subcontractors, and material men. So let's start first with the contractor. What is a contractor? Minnesota law defines a contractor as a person or entity that enters into a contract with the owner of the property. And that contractor or that person or entity will actually enter into a contract with a subcontractor to provide labor or skill to the property. Or that person or entity will actually have to buy materials from a material supplier to complete the project, whether it be lumber, whether it be drywall, whether it be cement or gravel, whatever it happens to be, is if the contractor, that entity or person that is entering into contract with an owner, if they purchase supplies in order to finish or complete the project, then at that point, and they enter into a contract directly with the owner of the property, they are then defined as a contractor, and they're required to provide a certain mechanics lien pre-lien notice in order to allow the contractor to come back later and lien the property. Now, the contractor's notice is what's on the screen right now. And a contractor notice essentially states that any person supplying materials or labor for the improvement must file a lien against the property if that person is not paid. Now, it goes on from that to essentially also state that a subcontractor has the right to also file liens against the property to preserve their rights. And they have to file their liens within 120 days after the last day of work. And this information is to provide the homeowner or the property owner information as it pertains to the contractors or the subcontractors' lien rights, so the homeowner understands what those rights are and what they're able to do to protect themselves, as well as what the rights of the contractor are and subcontractors are if the homeowner does not provide payment to those entities or individuals that are performing work on behalf of the homeowner. Now, the requirements of a contractor's notice are that this notice shall be included in a written contract. So if the contractor has a written contract with the property owner, this notice, in order to be a valid notice, must be included within the contract. I think it's good policy that you have the homeowner actually initial near where that notice provision is, so there is no dispute, there's no mistake that the homeowner or the property owner saw that notice. Also, the contractor has a requirement that they are obligated to provide a copy of the contract to the property owner. If they do not provide a copy of the written contract to the property owner, the mechanics lien is void. If there's no written contract, the contractor's notice must be delivered personally or by certified mail to the owner within 10 days after the work is agreed upon. Not when the work starts, but after the work is actually agreed upon. So you as a contractor, if you have a conversation with the owner and you agree upon the work, and you do not have a written contract, it's your obligation, it's your responsibility to make sure you provide that pre-lien notice by certified mail or personal service within 10 days after you agreed upon what that service that you're going to provide is. Make sure that you don't do it, again, 10 days after you start the work, because that may be too late. Finally, the notice must be in writing in capital letters that are in 10-point or greater font. It's important to include all that information, and also I think it's important to have a written contract with the homeowner to define the scope of the project, define the scope of what you as a contractor are going to do for the homeowner, as well as the price, as well as to address issues that may come up when it comes to change orders or any kind of change in the project and how those things are to be addressed. Without a written contract, there is a greater likelihood that there may be a dispute that arises, and you want to try to avoid the disputes at all costs. Now, there are certain cases when notices are not required. Notice is not required to any corporate contractor of which the owner of the improved real estate is an officer controlling shareholder. To any contractor who is an officer controlling shareholder of a corporation which is the owner of the improved real estate, or to any corporate contractor managed or controlled by substantially the same person who managed or controlled a corporation which is the owner of the improved real estate. Now, I think it's always good policy to provide the Mechanics Lien notice to make sure that you are covered. Because if you do not provide the pre-lien notice, you may be in a dispute as to whether or not one of these exceptions apply to your situation. Now, that includes part 1 of our Legally Speaking series on Mechanics Liens. Join us for part 2, the subcontractor and the subcontractor's notice.